Good afternoon. Welcome to our webinar, Past Performance of Government Contractors, Obtaining It, Using It, and Defending It. My name is Kathryn Flood, and I'm joined by my colleague, Sam Finnerty. We're attorneys at the law firm of PilieroMazza. PilieroMazza is located in Washington, D.C. We're a full-service law firm specializing in the representation of government contractors.
Sorry, we just got a quick question here, so we're just checking to make sure we don't have any technical difficulties. Someone chimed in saying that they couldn't hear us, so we're hoping everyone can hear us. It looks like everything's good on our end, but okay, good.
Thank you.
Right.
Sorry about that. So we're a full-service law firm located in Washington, D.C. We specialize in representing government contractors. We perform services in both litigation, labor and employment, and corporate work. Sam and I are both members of our firm's government contracts group. And today we're going to walk through some of the issues surrounding past performance and the submission of past performance, the overview, and defending it. So just real quickly before we dive in, an overview of what we're going to be talking about today. First, we're going to talk about the general rules governing past performance evaluations. First, what is past performance, and when do federal contracting agencies have to consider it? We're also going to talk about the different types of past performance information offerors can utilize, and past performance information we're going to be referencing as PPI, abbreviating as PPI throughout the presentation. We'll also be discussing best practices for obtaining positive CPARS ratings, which I'm sure a lot of you know that's really the nitty-gritty of what's spelled out as part of your past performance package, and obviously the references that you use going forward. Finally, we'll discuss how and when to challenge negative CPARS ratings. So this is really getting into how you defend your PPI going forward, including where is past performance reported, how is past performance evaluated, when can you challenge negative past performance, and what relief is available for a past performance challenge.
So just as a brief refresher for those in the audience, just generally what is past performance? So past performance refers to a contractor's performance on active and completed contracts. It's used, the reason that it's used often in evaluating contractors for future awards, the rationale behind it is that the way you've performed on prior contracts of similar size and scope that would be deemed relevant during an evaluation is going to be a good indicator or predictor of your capability to perform a contract that's being considered for award. So as it relates to what we're talking about today, agencies are generally required, depending on the type of procurement at issue, to evaluate past performance and consider various sources of past performance information when they're making their source selection decisions. And as I'll get into in a minute, this pertains, as we're talking about it today, to negotiated procurements and determining whether prospective contractors are responsible. That is a separate component. So it's important because poor performance under a federal contractor or poor performance under a federal contract can have the immediate impact of causing a contractor to be terminated for default, subject a contractor to damages. But with respect to what we're talking about today, it can affect their ability to obtain future work. So it's a pretty paramount consideration in the evaluation context. So as I touched on a second ago, just as a point of distinction here to start off with, there is a difference between past performance and responsibility. Responsibility is, it's a sort of a yes-no assessment as to whether the contractor has the financial resources and the integrity, the capability to perform the contract. So the rules pertaining to a responsibility determination are in FAR 9.1. But like I touched on a second ago, if you're terminated for default on a prior contract and a contractor has that on their record, that could certainly impact a responsibility determination that's being made on a future award. So although we're mainly talking about past performance today, it's important to also contemplate the effect that a default termination can have and whether that's something that you want to appeal or sort of try to challenge, because it can definitely have an effect on responsibility determinations down the road. With respect to what we're talking about today, past performance information and a past performance evaluation, this is one of the several comparative evaluation factors that's used when we're talking about negotiated procurements to determine whether and who is the best value contractor. So this does not apply to sealed bids under FAR Part 14, which are determined by awarding the contract the lowest price responsive and responsible bidder. So in the LPTA context, an agency does, however, have to define how past performance will be rated as unacceptable, but GAO has held that in the LPTA context, past performance evaluation is not necessary because it would essentially just be duplicative of the responsibility determination that the agency is already required to take. So I'm just going to go over now sort of where the general rules can be found for past performance information evaluation. For negotiated procurements, this FAR Part 15 we're talking about. The FAR indicates that the agency should consider past performance information from predecessor companies, key personnel, and subcontractors that are going to perform major or critical aspects of the work. For IDIQ contract ordering under FAR 16, FAR 15 rules don't apply. So in a FAR Part 16 context, the agency could consider past performance, for example, on a pass-fail basis, or they could even preclude offerors from submitting past performance references. But FAR Part 16 does indicate that the agency should consider past performance on earlier orders under the IDIQ contract itself. Now, when talking about FAR Part 8, schedule ordering, the FAR says that the agency may consider past performance. It doesn't explain what the agency has to consider, though. So the key thing to just note at the outset here is that under the FAR, the agency is not required to consider any specific source of past performance information. Also, in addition to any past performance information an offeror submits in a given procurement, agencies can also consider other sources of past performance information, such as information in various federal databases that they have access to, and information that's, quote, close at hand. So just, basically speaking, if a solicitation is unclear about what types of past performance information are going to be evaluated, an offeror should not assume that they'll be able to rely on any of the given sources outlined here above: predecessor, subcontractor, key personnel, any of those types of past performance. So I'm just going to touch now on the various types of sources that an offeror may be able to rely on in preparing its past performance proposal. So first topic here is, when can an offeror use subcontractor past performance information? And the answer to this is, as with most of these, it's really going to depend on the type of procurement and then also on the solicitation terms themselves. So for FAR Part 15 negotiated procurements, as the earlier slide said, the agency may consider, so this is discretionary, and it's may consider where the subcontractor is going to have a substantial involvement in the performance of the contract. FAR Part 8 does not have any defined rules, but there is some case law from GAO that has sort of stepped in to fill in the blanks here. And this somewhat recent case, Atlantic Systems, that's highlighted here, essentially established two separate default rules. So these are the rules that would apply. First, you want to look at the solicitation to see what the terms of the solicitation say, because that's what's going to control. But if the solicitation is ambiguous or it's not clear as to whether subcontractor past performance information is going to be considered, there's essentially two default rules. So if it's a FAR Part 15 negotiated procurement, GAO has essentially said the agency must consider past performance references submitted for proposed subcontractors if at least major subcontractors that are going to be performing critical aspects of the work. Now, the Atlantic Systems case dealt with a FAR Part 8 procurement. And so the default rule that was upheld there, if it's a FAR Part 8 procurement, the agency has discretion. So they can disregard subcontractor references if the solicitation itself is silent as to whether those references are going to be considered. And so in this Atlantic Systems case, GAO denied a bid protest where the protester was alleging that the agency had erred in the FAR Part 8 procurement at issue there by failing to consider the past performance and experience of a proposed subcontractor, where the solicitation in that case was silent on the issue. So with respect to subcontractor past performance information, the key takeaways here are that, if you really want to be proactive about this, if subcontractor past performance information is something you really would like to rely upon, if it's going to make your proposal more competitive, it's going to give you an edge and allow you to submit better past performance references. If the solicitation is not clear on this point, you should really try to seek clarification and sort of see if you can tailor the terms of the solicitation to fit your goals. You can do this maybe through a Q&A, informal questions submitted to the agency during this proposal phase. You could also potentially submit a pre-award protest challenging the terms of the solicitation itself. Subcontractor past performance is one of the areas where, although the agency still has discretion, it's generally becoming more and more the norm to allow subcontractor past performance. So the agency really has to have some sort of justification for precluding it, at least in a negotiated procurement under FAR Part 15. So if the agency is outright saying that they're not going to consider any subcontractor past performance, that might be something that's worth protesting if it's, to the extent you can argue it's unduly restrictive and the agency really has no real rationale. Now, that being said, they might be able to justify, and there are cases where they have justified excluding subcontractor past performance, where, to fit the specific needs of the agency, they really need to ensure solid prime contractor past performance to ensure that the requirements of the contract are fulfilled. So that being said, if you do intend to rely on subcontractor past performance, if it's clear that it's going to be allowed, you want to make sure that it's going to be counted. So you really want to articulate in your proposal, make sure the name of your subcontractor is clearly defined and laid out, and the work they're going to be performing is clearly mapped out in your proposal, so that the agency can really see that this is going to be a major subcontractor and that their past performance should be counted. But some solicitations are also going to say that although an agency will consider subcontractor past performance, they are allowed to give weight according to the relative amount of effort performed by the parties. So just keep that in mind, because that really puts the burden on the offeror to tell the government, the exact levels of effort that the subcontractor is going to be performing as compared to the prime. So if you have that type of provision in a solicitation, you really want to make sure that you're doing the heavy lifting so the agency doesn't have to, so that you make sure you get credit for past performance that you're trying to rely upon. So what about key personnel PPI? As noted earlier, FAR Part 15 says that the agency should take this into account, key personnel who have relevant experience. So as it relates to sort of how case law has developed to expand upon that point outlined in the FAR, the GAO has held that a solicitation can, however, expressly prohibit an agency from considering key personnel, and that would not violate the FAR provision. It's important to keep in mind this is all discretionary. The agency has a lot of discretion in the past performance context. Key personnel, unlike subcontractor, past performance is not developed quite as strongly to be an area that the agency really should be considering. So there's going to be even more discretion in this area, but just keep in mind that if you're looking through the solicitation and it allows for key personnel past performance, that may be something that you can use to differentiate your proposal and to build a stronger past performance submission.
Yeah, sometimes I think it's also useful if you're a relatively new company or your company is a startup and it doesn't have the corporate experience, but for example, your president has over 20 years in the industry that you're participating in. This is where you would try to get that individual's past performance and experience noted for evaluation purposes.
Yeah, that's a good point, Katie.
So now we're going to discuss when can an offeror use affiliate past performance information. We get this question fairly often with regard to our clients who want to know, I've got a sister company, for example, tribally owned companies. I have a sister company who's done a lot of work in this for this particular agency or for this particular contract site, and we want to use their past performance or references for this job. Can we use it? Well, GAO has held that an agency may consider PPI of an affiliate so long as it's not expressly or explicitly forbidden by the solicitation. And as Sam was mentioned before, it's very important that the offeror's proposal represents how the affiliate's resources will have meaningful involvement in that contract performance. So it's really important, if you want to use the past performance of an affiliate company, that your proposal does a very good job spelling out exactly how that affiliate that affiliate will be involved during contract performance. For example, its workforce, its management, its facilities, or other resources. Like, for example, if you're a construction company and you want to use the equipment of an affiliate that you're affiliated with during contract performance, make sure that you put that in there into the proposal. Meaningful involvement is kind of a term of art and will be determined on a case-by-case basis. So merely identifying your affiliate in your proposal, that's not going to be enough in order to be able to rely on their past performance. Really, what the agency is going to want to see is a firm commitment of that affiliate to the contract performance. You should also consider how you use the affiliate to support contract performance, such as a major subcontractor or a resource for key personnel. If you're going to use an affiliate's key personnel towards your past performance experience, you want to make sure that they're fully committed to contract performance. So for example, you have letters of commitment that you include in your proposal to demonstrate to the agency, this isn't just a name we're including here, we're actually going to be relying on this person during contract performance. You can also consider submitting the bid with an affiliate as a JV. We'll be discussing in a few slides how the experience and past performance of various JV members are considered during an evaluation. Essentially, what's going to be important is that you disclose the relationship of your affiliate in the proposal, and you clearly explain how those resources are going to be utilized during contract performance. Now, if you go back up to the first bullet, you'll see that PPI of an affiliate can be considered as long as the solicitation doesn't expressly forbid it. If you're not sure if the solicitation won't allow that, then it's worth seeking a clarification if you can use affiliate past performance in your proposal.
And just to make sure everyone understands, one of the abbreviations we're using here, PPI, as most of these slides are indicating, that's past performance information. So we broadly use that acronym because it includes not only since the agency can consider other sources of information, PPI is going to be the past performance references you submit as part of your past proposal, but then also agencies can do their own sort of hunting and looking at databases that they have access to. So that's just generally past performance information we're talking about today.
So for tribally owned companies, which I mentioned a little bit earlier, this is where really you can, we get the questions with regard to using a sister company's past performance information or experience in a tribally owned company's proposal. So yeah, the general rules regarding use of affiliate past performance apply. However, you're going to want to be especially cautious when relying on affiliate past performance information for tribally owned companies. There's a pretty broad exclusion from affiliation for tribally owned companies for 8A procurements, but those firms can still be found affiliated for other reasons. So if you're trying very hard to make sure that your sister companies are all maintaining a fairly well-defined clear fracture between the other companies, so that SBA doesn't come later find you all to be affiliated together, you want to be fairly use your discretion when you submit this past performance information for new procurements, in case that could become an additional piece of evidence to support finding of a general affiliation. This is not to say that you can't use your affiliate's past performance when you're a tribally owned company, because that's one of the major benefits of all being under one overarching umbrella organization. You just want to use it with discretion. Joint ventures are also able to use the past performance information of their individual venturers. However, the FAR does provide very little guidance on this topic. But as with other areas, as Sam has explained earlier, GAO has kind of come in to fill the gaps with regard to when you can use the PPI of the JV members and when you can't. Recently, SBA's revised its regulation to make clear that for at least small business joint ventures or all the other JVs that you can form under SBA's various socioeconomic set-aside programs, the procuring agencies are required to consider past performance information from each JV partner, as well as any work done by the JV itself. And you know that's important because for small business joint ventures, at least most of the time, these are entities that you create for specific procurements. So they don't have a lot of corporate experience. They're usually created like a month before you submit your proposal. So that the JV entity in and of itself is not going to usually have much past performance information to speak of. So that's why SBA's regulations stepped in and say procuring agencies are required to take into account the past performance and experience of the individual venturers of that small business joint venture to address that deficit. However, GAO has said that at least when the JV is between a mentor and a protege, so that's a small business joint venture formed between a mentor and a protege under SBA's All Small Mentor Protege Program, or 8A Mentor Protege Program. Ordering agency or contracting agencies, they are allowed to take into account how much work each individual venturer will perform in considering how they weight specific past performance from each venturer, or conversely, the ownership of the JV. If the small, like for example, a mentor protege JV is usually majority owned and controlled by the protege, 51%, 49%. So as GAO has said, it's appropriate for a contracting agency to create RFPs which ask for more past performance information from the managing partner of the JV, the protege, than the mentor. So it's really, in addition to SBA's regulations, you really need to make sure that you're checking the requirements of the RFP and are abiding by them. And even though SBA has said that it's required that the contracting agencies take into account the experience of each individual venturer, the agency can still ask for past performance from the entity itself. So conversely, when can an offeror use past performance information of a JV in which it was a member? So this is when you've participated on a specific procurement as a member of a JV, and now you want to use that information to that past performance on a new procurement where not necessarily the JV will be involved, but you want to, as the member of that JV, want to leverage that past performance. Unfortunately, that's only clearly permitted when the offeror was the managing member or at least the 50% partner of the joint venture. So for example, back when I just was speaking about the mentor-protege joint venture, where the managing member is the protege and they have a 51% ownership interest in the JV, that would be the member which could then explicitly use the past performance of that particular JV going forward. the mentor, as the 49% owner, it's not as clear that they would be able to use that past performance. An offeror can only rely on the past performance information of a JV it controlled under rules for affiliate past performance information. So there is a presumption that individual venturers are affiliated with the JVs that they've participated in the past. So you can use that past performance information similar as to the way that you use affiliate past performance. And we've discussed how you can leverage affiliate past performance. And additionally, OHA, the SBA's Office of Hearings and Appeals, have weighed in and said that the agency may consider the performance on the basis that the offeror had a sufficient role in the JV to make the performance relevant. And so that term, sufficient role, what does that mean? Using the mentor-protege JV example that we were going back to earlier, I mean, if the mentor is the 49% owner of the JV, but is performing up to 60% of the contract, I think that's fairly clear that, you know, that mentor probably had a sufficient role in JV performance and should be able to utilize that past performance experience.
And so I think this is also just another important area, because this is developing a lot more in recent years as joint venturing has become more popular, as SBA's mentor-protege programs have allowed large and small businesses to form mentor-protege relationships and then form joint ventures to gain an exclusion from affiliation. This is being done a lot more, and given, you know, that this is not something that's defined in the FAR, SBA's regulations do indicate that the procuring agency is required to consider the past performance of each member to the joint venture. This is, you know, but the relative weight and how it's going to be considered, and then also how past performance is going to be considered where you were just a member in the joint venture is becoming more important. So this is something you're going to want to clarify, especially if you're, you know, a small business that's just getting started, that doesn't have a lot of past performance. Maybe you formed a joint venture with another small business, but you were the minority member of that small business. So now you're in a situation where you've got this great prime contract that you both contributed to meaningfully, but, you know, you were the 40% owner of that joint venture. But it was a big contract. It was relevant to something else that you want to go after, and you'd really like to get credit for that. This is something that might be worth, you know, sort of socializing with the agency ahead of time to see if you can get some clarity on whether that type of reference would be considered, because it could be critical to you being able to submit, you know, a really advantageous past performance proposal.
Well, that's a great point, Sam. Thanks. Additionally, we wanted to make sure we covered how to utilize and leverage past performance for CTAs, contractor teaming arrangements established under GSA schedules. So we've seen CTAs become very popular in recent years as more and more procurements are pushed towards GSA schedule buys. And so it becomes necessary for contractors to form these teaming relationships known as CTAs to kind of pool their resources and go after particular RFQs together released under the schedule program. Now, if you remember Sam's note from a little while back regarding FAR Part 8 procurements, because FAR Part 8 governs GSA schedules, agencies have a lot of ordering agencies have a lot of discretion on how they utilize past performance information and evaluate it during FAR Part 8 procurements. So the question becomes, when you form a CTA, which CTA team members' past performance are you allowed to leverage? So CTAs are not like prime subcontractor relationships, because each individual CTA team member is responsible for its duties, has privity of contract with the government, and must have a GSA schedule contract. So these are all CTA team members, I mean, theoretically are considered co-primes for the opportunity. And all have their own GSA schedule contracts. So they are all operating under their own, you know, terms and conditions of their contracts. So there is a very good argument that agencies should allow CTA offerors to rely on the PPI of all of CTA team members, that it's unreasonable to limit the past performance information to only the CTA team lead, for example, because all CTA team members are supposedly considered prime contractors. Long story short, I think that if the RFQ comes out and it's not clear that the agency is willing to accept the PPI from all CTA team members, you should ask for clarification on that point. And if the agency is not willing to budge, we would say consider submitting a pre-award protest, because that would make the solicitation unduly restrictive.
Yeah, and this is going to be a situation where if you've got a lot of, if you've got multiple companies that are party to that CTA, you might not have subcontractors. So, you might not have the ability to be relying on subcontractor past performance. And if, if you're forced to only rely on the past performance of the CTA lead, that really might be a hindrance to the ability of the CTA to submit an advantageous proposal, because it, teamed together with all these other companies thinking that it would bring their experiences to bear for performance. So it really might be something that's worth addressing with the agency. So I'm going to talk now about when you can use acquired past performance information. So this is, whether you're acquiring a company through a merger. This is going to touch on novation as well. As I said at the outset, FAR Part 15, which is has the most broadly laid out provisions pertaining to what the agency should consider, again, discretionary, but it does say that the agency in a negotiated procurement should rely on past performance information of a predecessor company. The FAR elsewhere defines a predecessor as an entity that's replaced by a successor. And in turn, it defines a successor as an entity that has replaced a predecessor by acquiring the assets and carrying out the affairs of the predecessor under a new name, often through acquisition or merger. Makes the distinction, however, this does not include new offices or divisions of the same company, or a company that changes its name only. So generally speaking here, where the offeror is a complete successor in interest because there was a merger, corporate reorganization, or there was a sale of an entire business, that complete successor in interest should be able to rely on the past performance of the predecessor company it just acquired, as a general proposition. However, this issue really is not as clear when the offeror is not a complete successor in interest to an entire company. So, for example, if it's only a successor in interest to certain contracts or assets that it's acquired, where there's been, a novation, but there hasn't been a full merger or a full asset sale or things of that nature. So I'm going to touch a little bit now on relying on acquired past performance where there's been a novation. So when you have a novation, that's where you're requesting the government to recognize a third party as a successor in interest. So in that situation, the transferee to the transaction has to assume all of the transferor's obligations under the contracts as part of the novation agreement. And when the contracts are novated, they're going to be assigned the cage code of the successor entity. So it stands to reason that after the novation is complete, they should be able to rely on that past performance, because the predecessor's contracts are going to all show up in CPARS under the successor's cage code. However, GAO, in analyzing this over the years, has said that novation alone doesn't by itself require an agency to attribute past performance information of a predecessor to a successor. Because, at the outset here, we mentioned when you're talking about past performance, the reason this is such a critical evaluation criterion is that past performance is it's a benchmark. It's sort of a standard. It's like the indicator of your ability to perform the contract at issue. So that's really what the heart of all of this analysis is trying to get to, whether this past performance, this great past performance we're trying to rely upon, actually is going to have any effect here on what the agency is acquiring and your ability to successfully provide either the services or products that are being delivered. So in a situation where you have a novation, you might be novated a contract, but you're just getting the contract. The contract was performed and all the people that performed it aren't necessarily coming over. So there's situations where it might not be all that, just because you've acquired that contract doesn't necessarily mean that it's going to be indicative of your future performance on a different contract if you don't have all those same resources. So as the case law is developed here, the GAO has held that the key consideration in this area is really whether, and this is kind of similar to how how it's done for subcontractors and affiliates, as we've touched on. The key consideration is really whether the experience that's being evaluated, i.e. this past performance reference, can reasonably be predictive of the offeror's performance under the contemplated contract. And where it is predictive, GAO has recognized that such a successor company in that situation can rely on the past performance of a company. But the key is going to be that you really acquired all of the assets that were associated with performing that contract that you're submitting. So if you've acquired a company, or you've acquired part of a company and some contracts have been novated, service contracts, and you want to rely on the past performance of that service contract, it's going to be helpful to show that you acquired the office furniture, the key personnel, the employees came over and started working for the new company. So really all the people that made that past performance so great are now with the company that has the contract. So their excellent past performance on that contract should reasonably be attributed to this new company that now has the contract.
So now we're going to quickly discuss how, once you've garnered this experience, you've worked through all these contracts, you've delivered successful performance to the agencies. So how do you best use past performance information going forward? A lot of this is going to be dependent on how interactive you are with the agency with regarding preemptively. For example, Sam and I have been discussing in the previous sections a lot of times where we suggest, asking questions, clarifying questions to the agency. How can you, what type of past performance will you consider? How are you going to be evaluating it? Going forward, we recommend trying to shape RFP requirements to fit your needs. That's a part of the whole procurement process. You can try opening informal dialogues with the contracting officers, submit comments to draft solicitations as they're released on FedBizOps. Make sure that you're emphasizing specific points during Q&A. For example, are you going to be submitting questions to the agency, such as, are you going to be considering who's contributing equipment to this particular solicitation and contract performance? How will you evaluate affiliates that are going to be utilized during contract performance? And make sure that your protest unduly restrictive or ambiguous RFP language. Once proposals go in, it's too late to challenge anything that's unduly restrictive of competition. That's it. So it's important, as these procurements are released, that you're interacting with the agency and trying to shape those requirements to best suit the past performance information that you have, and make sure that you're submitting a competitive proposal. And then once you're comfortable with the RFP terms, making sure that you're providing PPI that's tailored to the RFP evaluation factors. So make sure you fully understand what the agency means when it says, for example, we're going to be we're willing to consider the past performance information for key personnel. Make sure you know what they mean when they use terms like that. You want to also make sure that you're actively monitoring sources of information for your past performance information. This includes CPARS, FAPIS, and PIPERS. You want to make sure that you know what's being said about your company. You have people on the ground ask clients what they've heard about your past performance and experience. What's your company's reputation? How are you presenting to your customer agencies? It's critical that you participate in debriefings. Know, for example, what your ratings are under your past performance information. What for past performance questionnaires, what was the information that the other agencies were providing regarding your contract performance to the evaluating agency. And you want to make sure that you examine your subcontractor teammates' past performance information before you use them. That's key. You know, you form these teams, but maybe your teammate that you're going to utilize as a critical subcontractor has a very bad CPARS that's hanging out there. That's important for you to know before you decide to propose them as a key subcontractor and rely on their past performance information in your proposal.
Yeah, you definitely don't want to find yourself in a situation where you've touted a subcontractor throughout your proposal. And, you know, like we said earlier, although you're limited often in the number of past performance references you can submit, and, you know, you submit the ones obviously that you think are relevant, that, you know, show your experience in the best light possible. You don't want the agency to go finding other sources of information that they have easy access to, or information they're aware of from, you know, a subcontractor performing a similar procurement on site or something, and, you know, dinging you in the evaluation because unbeknownst to you, this subcontractor or teammate of some sort has poorly performed on some procurement you're unaware of.
Yeah, it's critical to know that information. So once you've won the contract, what can you do to make sure that you're optimizing your past, what the agency is going to be reporting about your PPI in the future? For example, what your CPAR evaluation is going to look like at the end of contract performance. First, you want to make sure that you've fully vetted your quality assurance plans that you've submitted as part of your proposal and the performance schedules that you've committed to meeting. Know those inside and out and make sure that you're meeting and delivering all objectives in those particular plans. During contract performance, you definitely want to make sure that you keep track of any kudos that your people are receiving on the ground, or that the agency has been receiving, any awards that you've received. Keep a file and make sure that you're actively tracking that. Ask your people on performing on the contract, they forward any emails that praise their contract performance to you, so you're keeping them on file. On the flip side of that, you want to make sure that you're immediately rectifying issues as they arise. You know, you're waiting for the issue to blow up, that you're actively communicating with the contracting officers or the corps assigned to your contract, and trying to make sure that you fully alleviate any performance issues as they arise. You also want to make sure that you're continuously assessing whether you're on track to meet the performance milestones. You don't want to all of a sudden, you know, realize that you're 6 weeks late on delivering a major deliverable, and you only realize it because the contracting officer has emailed you and said, hey, where is it? You know, that's when you're coming towards the end of contract performance and it's time for the CPAR evaluation, that's most likely going to get noted. Finally, it's important to know that the PPI rating justifications and stay within the contract's period of performance. And we're going to discuss in a few slides all the various categories of a contract performance that the agencies are going to be evaluating at the end, and then also what they take into consideration for the particular ratings that they assign: excellent, outstanding, you know, satisfactory, marginal. So you want to make sure that you know what those ratings mean and that you're not going to get dinged on anything that will put you down to a lower rating than you deserve for your performance.
Yeah, I think related to this, it's just you want to make sure, you know, you win the award. That's the, you know, that's the key goal. But then it doesn't stop there. You really want to make sure at the outset of performance and throughout performance, you're doing everything to make sure that this contract you just won is going to become a good past performance reference for you down the road. And a lot of that is figuring out what the expectations of the agency are. Unfortunately, one of the things that's happened in recent years, CPARS statistics have unfortunately shown that satisfactory ratings are kind of becoming the new norm. And, you know, for any company that's had a lot of past performance evaluations, you know that satisfactory ratings can, you know, can make all, if that's all you've got, you know, you've got a really tough chance of winning contract awards. You want those higher ratings. So with the trend regressing towards satisfactory ratings, it might be a good idea at the outset of contract performance to talk to the contracting office and say, hey, you know, what do we have to do to get those exceptional ratings, those outstanding ratings? Because you know, we want to exceed what the requirements are to make sure that we're we're getting ourselves into a situation where we should be given those types of higher ratings. So I'm going to talk a little bit now about defending your past performance. CPARS is something we've talked about a lot. That's the Contractor Performance Assessment Reporting System. That's where your past performance ratings are going to be input into CPARS. Agencies have to consider the information that's in there. It's tied to some other databases that we've talked about that have been mentioned here: FPDS, PIPERS, and FAPIS. The evaluations have to be that are put into the CPARS system. They have to include a clear non-technical description of the contract and clear relevant information that accurately depicts the contractor's performance, and it has to be based on objective facts supported by performance data. So there's certain prescribed evaluation factors that are going to be included in a CPARS. These usually include quality, cost control, timeliness, management, and utilization of small business subcontracting. So those are the different areas that are going to be evaluated, and it's usually a rating that's assigned for each of those specific categories. So there's different types of CPARS evaluations that you'll receive. There can be interim and final evaluations. The interim is essentially if it's a long-term contract that exceeds, if it's a contract that exceeds a year, all annual evaluations that you get are going to be interim evaluations, except for the evaluation that's completed at the final year. But it's important to remember that each interim evaluation is really only supposed to reflect the prior at least 180 days, but it can include up to an entire 365-day period of performance. With agencies being, bogged down with lots of things on their plate to do, we're finding a lot of CPARS for long-term contracts, will be years late or be assessing multiple years of performance. That's really not how it's supposed to be done. So, if you think you've got good performance, you want to keep an eye on these deadlines, and you might want to just ping the agency on this and say, hey, are you planning on doing an interim evaluation? Where do we stand? So that the people that were there on site aren't, not available 3 years down the road when they're struggling to catch up and do their evaluation. So the final evaluation is completed at contract or order completion. It does not include cumulative information, like I just said, so it really should only be for the period preceding the last evaluation that was done. Someone mentioned earlier how long past performance information is valid for. So it's generally 3 years or 6 years if it's a construction, architect, engineering contract. So these are the ratings and narratives that are outlined in the FAR. It's really important, and it's critical in challenging a CPARS rating that you be familiar with and understand what these definitions mean, because if you're arguing that you shouldn't have gotten a satisfactory for a given management or quality or your cost control, you really need to be able to argue why you should have gotten a very good based on the definition for very good or an exceptional. It's also important to keep in mind that CPARS aren't required for all contracts, so there's different dollar thresholds between DoD and civilian agencies. So for example, CPARS for civilian non-construction contracts are required for contracts that exceed the simplified acquisition threshold. I think for construction contracts, it's got to be over 700,000. So there are different thresholds for when a CPAR is going to be required. So for small simplified acquisition contracts, that's not going to be likely that you're going to have a CPAR.
So hopefully all of your CPARs are excellent or very good, and that there's no need to issue a rebuttal to what you receive. But unfortunately, as Sam said, the trend has been towards the negative. So what do you do when you receive a negative CPAR and you want to be able to respond to the agency, or the information contained therein is not accurate? So like Sam was saying, the agencies are supposed to provide contractors the CPAR evaluation as soon as practicable after completion of the evaluation. Sometimes that happens, oftentimes not. But as soon as you receive the CPAR, contractors have 14 calendar days from the date of notification to submit comments, rebutting statements, or additional information. So this is once you review the CPAR, you realize that, you know, the agency got some of the facts wrong, or for example, that they noted a specific instance during your contract performance, but they didn't include the information regarding the corrective measures that you took, or the contributing factors towards the reason why that there was a particular problem. You do have 14 calendar days to submit that additional information. So after 14 days, the CPAR is automatically published on PilieroMazza, together with the comments that you submitted, hopefully after, you know, as a rebuttal. On day 15, those evaluations are accessible to source selection officials through PilieroMazza, with or without your response. So essentially 15 days after you receive that notice, that information is going to be publicly available to the source selection officials. Not publicly available, but available to source selection officials. You are allowed, contractors may submit comments up to 60 days after the notification to the contractor, and those comments can be included in the PilieroMazza system once they're submitted, but it's really the comments that you submit within 14 days after the initial notice that are going to be included, and at least in that initial record. So what are the types of things that you want to keep in mind when you're rebutting a specific negative CPARS? First, you want to review the notice that you receive and make sure that the procedural and factual information are correct. You want to address any substantive deficiencies in the evaluation, specifically any failures to follow the requirements of the FAR. And you also want to make sure that you point out any mistakes in the facts supporting the evaluation. So it's important that you know, if the facts are wrong, put that in your response. You want to include copies of supporting information. That's when it becomes important to make use of that record that I talked about before, you know, regarding kudos or any information that you're receiving during contract performance. You can submit that as part of your response, and as a rebuttal for the negative information included in the CPAR. If you have pending proposals and you disagree with the ratings that are out there in a particular CPAR, you can ask the procuring agency not to rely on the negative information in that particular evaluation until it becomes a final decision. The agency is still allowed to consider that information, but they can be persuaded that reliance would be unfair and prejudicial without the review of your particular rebuttal. Also, there is a way that you can avoid publication of these negative CPARs. If the information included in the CPAR is just factually incorrect, and you have major issues with what is printed in the evaluation, you can ask the agency that printed that published the information if they would be willing to take it off make it inaccessible to other source selection officials pending resolutions of the issues. You can ask for meetings, you know, submit the claim, which Sam is going to talk about shortly. Unfortunately, injunctive relief at court is rarely granted in these types of situations.
So how do you challenge a negative CPAR if you get one? So any disagreement with any aspect of the CPAR has to be reviewed by a reviewing official at a level above the contracting officer per the FAR, and they have to issue a written decision, which then becomes part of the evaluation and is then also available on the federal databases where these evaluations are housed. So the entire process, including this review, is supposed to, including the comment period and the reviewing official's final decision, is supposed to be completed within 120 days of the end of the contract period of performance. So if you get a final evaluation that you still disagree with after submitting your comments and the comments being reviewed, there's no formal appeal process outlined in the FAR. So you have to look to the Contracts Disputes Act and the disputes clause of the contract itself. So the CDA does permit appeals to the Board of Contract Appeals or the Court of Federal Claims of final decisions of contracting officers in response to so-called claims by a contractor. But you have to establish standing. And so this is critical. If you want to appeal a final evaluation, standing is going to be a critical thing, because often contractors find themselves in a situation where they've submitted comments during the evaluation process, but there's precedent out there indicating that just your informal comments or additional information you added, that doesn't necessarily constitute a claim for purposes of standing under the CDA. So just because you've submitted some objections or comments, that's not going to necessarily get you into court. So to ensure standing, what you want to make sure you do is that you submit, and we advise our clients to submit a separate claim itself with the necessary language in there to establish standing, challenging that reviewing official's final decision, and seeking specifically, and this is the key thing for standing, a contracting officer's final decision under the disputes clause of the contract. So claims, you have a long time to file these, but obviously given that past performance information goes stale after a certain time period and the past performance references are available and reviewable after 15 days, you could wait 6 years like all other claims, but you probably want to do this quickly if you haven't gotten the relief you wanted by negotiating at the early stages. So once you submit the actual claim, there's time periods that are going to kick in as to when the contracting officer has to respond to that. If they fail to respond within the required period of time, you can deem your claim essentially denied and immediately appeal it. CPARS they're essentially usually viewed as non-monetary claims. So the time period within which a contracting officer has to respond to a CPARS claim is unfortunately pretty vague. It's just a reasonable time. What reasonable has been debated in lots of cases. There seems to pretty much be an acknowledgement between the courts and the boards of contract appeals that there's sort of like an 11-month line in the sand drawn. Anything beyond 11 months for a contracting officer getting a decision to you is unreasonable. So if they take longer than 11 months, you can deem it a denial. But given that CPARS claims are not all that complicated, if you don't get a response from the contracting officer within a couple of months, you can probably you can consider viewing that as a denial and appealing it earlier. It's also important to just consider here when you're appealing this, you're going to court. Katie touched on this a second ago. Injunctive relief is not available. The type of relief you would get in a case, the board can't direct an agency to remove or revise a CPAR. So if you succeed in an appeal, what you'd get is a declaratory judgment, essentially stating, it would be an order from the board essentially stating that the CPAR was unreasonable, was arbitrary and capricious, something of that nature. And that declaration that you now have, if the agency doesn't remove the CPAR or revise it from the system and it continues to hang out there, you now have this court order that you can use, and you can communicate that to other procurement officials in subsequent competitions to essentially say, hey, don't rely on that CPAR. It was deemed by a board to be arbitrary and capricious. Now, whether things actually go this far, it is important to note that this is becoming a more litigated area of government contract law. People are, given the trends that are heading towards more satisfactories being the norm, this is something that people are viewing as worth the effort to fight. And there was recently the first ever board published decision addressing the merits of a CPAR. So this means that this is an area over which boards do clearly have jurisdiction. It is something they can consider. And because boards have the review authority here, this is something that agencies need to be careful about when they're doing these evaluations, because they can be subject to review. So the takeaways here for CPARS are that you want to carefully and timely scrutinize all negative CPARs. As Katie touched upon, there's numerous reasons to challenge these. A lot of times the ones that cross our desk, frankly, at the outset, they've just got technical errors in them, things that are wrong. There's information in there sometimes that just shouldn't be in there. The assessing official has included names of contractor personnel, which isn't something that's really appropriate to do in a publicly available record, or they're just totally wrong. They're referring to things that had nothing to do with the evaluation. They're evaluating management in ways that don't adhere to how management's supposed to be evaluated under the FAR. Maybe they're evaluating cost control and it's a fixed price contract. So there's a number of just technical deficiencies you want to look at and see if there's, just things in there that are plain errors. But then also you want to make sure that they've really justified a narrative that supports the rating, because that's the burden on them. Also, you want to engage the contracting agency and act early on to figure out what you can do if you get a negative CPAR. And sometimes we can help clients get these things held back from publication while they're negotiating. Sometimes just some informal communication with the agency can lead the agency to promptly revise these. So there's a lot of stuff you can do before you have to find yourself in the full-blown appeal process and get yourself embroiled in litigation. So you want to review it with your team initially, probably to make sure that everything's accurate as it relates to how performance was done. And then we would advise that if it's really something you feel strongly about, if it's going to have an impact, you want to review it with counsel, because they're more often than not going to be the ones that are going to be able to come up with your arguments and point out things that the agency has not done to adhere to the FAR. So while this rebuttal, as Katie touched on earlier, that you submit is being reviewed, you want to ask agencies if they can hold off on relying on the data in that CPAR. This is something that you might be also successful in doing, even though at day 15 the CPAR is available for everyone's review. If it's really egregious and there's a ton of errors in there and you're going after another competition and you're concerned that the agency is going to rely on this negative CPAR, you might want to go to that procuring agency and say, hey, we're in the midst of negotiations with the agency. This is the subject of a dispute. We don't view the CPAR itself as it currently stands as accurate. So, we were hoping you could not rely on that, and that you might find some success there. Because as I touched on earlier, if that CPAR is ultimately deemed by a board or a court to be arbitrary and capricious, and an agency does then rely on it, even though you've made them aware of that, you might have a basis there for injunctive relief to say that you were prejudiced because an agency relied on a CPAR that had been deemed to be unreasonable, and that prejudiced you in the procurement. So these are just some things to keep in mind. And then ultimately, if you don't get the relief you want in informal negotiations early on after you get the CPAR, consider whether you do want to submit a claim. And that that might have the effect also of having your concerns be taken a little bit more seriously by the agency. And if you ultimately get a adverse decision on that claim, consider possibly filing an appeal to the board or the court, because they both have jurisdiction, and this is becoming a growing area of the law that, given how much discretion agencies have in performing their past performance evaluations, it really is worth fighting sometimes. So that's something you want to consider. So we've run out of time here. We do see that you all submitted some various questions here. What we can do is we will make sure we'll get back to everyone's questions after the presentation's concluded here.
Yeah, we'll go through and make sure we answer all your questions that were submitted. If you have any additional questions, please go ahead and submit them to either me or Sam. You can send our email. And thank you very much, everyone, for joining us this afternoon. We had a lot of content to cover, so I'm sorry we ran a little bit over, but thank you for joining us, and have a good rest of the afternoon.
Okay, I think we're done.